Will they return to work or won't they? Thousands of fired federal workers had their hopes smashed when the U.S. Supreme Court blocked the judge's order to rehire many employees that President Donald Trump then slashed from the federal workforce. So Queen City News Chief Legal Analyst RHODES joining me to be able to explain all this as to where we are right now by these recent actions by the nation's highest court.
Yeah, I mean, the easiest thing that you could look at when you're talking about these types of things are two words: stay and standing. Let's talk about stay first. If there is a underlining order that's in place that a lower inferior court judge has granted, has ordered, then any other judge that has an opportunity to look at that, a higher judge. So for instance, a U.S. District Court judge, any type of order that they put in place, only a higher court judge can do something with that. So that next court will be the Court of Appeals. They can either allow that order to stay in place, or they can allow it to be removed and set it aside. In this case, that didn't happen. It went to the Supreme Court. The Supreme Court, by a 7-2 opinion, stayed that order, basically removing it, pausing it, allowing it to disappear, so that the order that was originally in place, forcing those federal governments to go back to work, is now stayed, meaning it stopped. So then standing, when they talked about why they addressed this, and this is not a large opinion, this isn't something that was big. This 7-2 specifically just addressed standing. I talk about all the time, to get a case in front of the Supreme Court, first you got to get cert granted. You have to have the 4 justices that want to hear this case. That's how cert's granted. Thousands of cases come before the court. They only grant cert to a handful, and so you have to jump over that hurdle. But once you get there, the court will still examine and evaluate a couple of things. Well, do you have a right to be here? Do you have standing? Is this an issue of constitutionality? That's something that they often talk about. And do you have an injury in fact? That's the standing portion. Have you been hurt by this claim? So I brought this before the Supreme Court, or I brought this to some lower court. Well, did you even have a right to be there? In this case, the justices said no. The companies that brought this, these nonprofit groups, these organizations, didn't have standing. There were federal employees that were fired. The federal employees are the ones that had the standing to bring the claim. And they're saying because you guys weren't hurt, didn't have an injury in fact, then you didn't have a claim to be brought forth anyway. And so for that reason alone, not addressing the underlying issue, just saying that because they're not the right person or group of people to bring this claim, then the case doesn't even have a right to continue to go forward. And so they sent it back for the standing issue alone.
Okay, so that's why the Supreme Court is blocking it, I mean, essentially. So when you look at the court, it is a conservative majority. So was this decision at all very surprising?
And again, it's not really a blocking. It's just they're not even going to address the substantive issues.
Right.
They're just saying, before I can address the substantive issues, it's like a checklist. So I'm checking off a number of things. And one of the things is, do you have a right to even make this argument? Should you have even been able to bring this claim in district court? And the answer to that for the 7-2 majority was no. The groups that brought this claim didn't have a right to be there. Because they didn't have a right to be there, we don't even need to address this. Justice Jackson and Sotomayor dissented. Justice Jackson said you shouldn't even have got to the standing because we're talking about a preliminary injunction. And that is an extraordinary remedy in the judicial system, because the court on the lower court, inferior court, said that yes, they have met their burden, irreparable harm, likelihood of success on the merits, this balancing of the equities. Because they've met those standards, then this injunction should be in place. So there was a clear disagreement between the 7 and the 2. But if you're looking at the argument, the standing argument is something that the court has held up in the past. Typically, that standing would be if you're looking at the entire case. When we're looking at the injunctive portion of it, typically the Supreme Court would hold in place an injunction that's from a lower court if they've already made the analysis. And so I think that's what Justice Jackson was attempting to say, is we're not even going to get an opportunity to listen to this because you're throwing it out with the standing, which is kind of problematic because standing has already been established because it got to us.
All right. Is there something that we're missing with all of this that I just feel like it's the back and forth and back and forth?
Well,
and also, what's next?
That's the nature of the process. I mean, we've seen a lot of things that are not how it's supposed to happen.
Right.
There's a lot of talking about the judges. There's a lot of talking about the judicial system, a lot of saying how judges are liberal, judges are conservative judges. And that stuff is kind of newish and outside of the scope. But within the confines of the normal judicial process, you file a complaint, you have a hearing, a judge makes an order, either you like the ruling or you appeal it. And once you appeal it, then guess what happens? Now the other side has an opportunity to go back up to a new court. You don't get to add anything additional. They just look at the record that was presented in the lower court. And now at that other court, they'll say, I agree with the old court or I don't agree with them. And guess what? Then you'll still have another opportunity to appeal. Finally, you get to the Supreme Court, and now you have to be satisfied with whatever decision they make. If you're talking about, again, the substantive nature of the case, that wasn't what happened here. This only talked about the injunctive portion, which was them saying you guys have to send these guys back. But with the underlying case, does the president have authority to fire? Or that's something separate, and you have still lower courts talking about that. Most recently, even in this situation, you had a Maryland court that said most of these employees that we're talking about here still have to go back to work. And so you're still getting mixed messages from multiple courts. This isn't going to be resolved anytime soon, but it's working how the judicial system is supposed to work when you have litigation.
Colleague Rhodes, we are very happy to be able to have you break all that down for us. Thank you so much. Appreciate it.